Come up, Mr. Harrison.
Yeah.
Was today his regular setting, or was it a setting that we brought him in because he has bond violations?
Today's his regular setting.
Okay.
We had accepted the plea offer and we're ready to move forward today, before I got that email.
I have here that you have bond violation, Mr. Harrison, in that
This right here is where Judge Boyd sets the tone. Bond violations, especially involving alcohol in a DWI case, are a huge red flag. The judge isn't just scolding. He's legally warning Harrison that the next slip-up could land him in mandatory rehab or even behind bars. Watch how Judge Boyd lays down authority and compassion at the same time. That balance is what makes his courtroom moments go viral.
you were continuing to use alcohol. You are entering into a probation now, and I'm warning you that if you test positive again, I can amend your conditions, and I will, to put you into a rehab facility. And I can take you there kicking and screaming, and I don't care what is going on in your life. But if you continually show me that you cannot stop, then I'm going to do it my way. And I promise you, you're not going to like the way that I do it. It is a minimum of 9 months in treatment if you respond well. Do you understand? But it could be in an inpatient facility for up to 1.5 years of your life spent with me in jail. Do you understand? If I didn't get your attention enough last time, heed this warning now, because you will not get another one. You are charged with driving while intoxicated, second offense. They have agreed to reduce it to a first.
That's the real hammer. A motion to revoke means if Harrison violates probation, his freedom is instantly on the line. Notice how the judge spells it out like a warning shot. He's not threatening. He's outlining exact legal consequences. This is courtroom reality, not TV drama. One breath test, one drink, and Harrison's 9-month probation could turn into 180 days of jail time.
That you thank them, because thereby you are now not going to do 5 days in jail, because that would be the mandatory minimum for you if you plead on a second. But I'm going to tell you now, I'm going to keep you on a very short leash. And one false move, they're going to file a motion to revoke. And if they prove it to me that you violated this probation, get ready. For you to complete what are you pleading to is 180 days in jail to be probated for 15 months. As part of the conditions, you will do a repeat offender DWI education class. 2 victim impact panels. You must also do a TRAS. This TRAS is an evaluation to see what other conditions you may need. If they assess other conditions, which in my guess they're probably going to, you must fulfill those. It can be so much as intensive outpatient treatment, supportive outpatient treatment. Because you're continuing to drink while you're on bond for this case, it may very well say that you may need inpatient treatment. I don't know, but that's what you're agreeing to now. Do you understand? No drugs, no alcohol, random urinalysis. You must maintain a guardian interlock and a $100 one-time donation to MAD. One more thing that you must recognize here, that there is a requirement for a no breath test refusal. If you are driving in a car and you get pulled over, an officer asks you to submit to a breath test, you must submit to it. If you fail to, then they're going to take you to jail and you're in violation of this probation. Do you understand? You give up many rights by entering into this agreement. You give up the right to a trial, right to compel witness.
At this point, the tension peaks Judge Boyd's, making it crystal clear. Next time is not just a slap on the wrist. A third DWI becomes a felony with years in prison. What do you think is this tough love approach the wake-up call defendants need? Or is it too harsh? Drop your thoughts below. This is where opinions split.
On behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. Under federal law, you give up the right to appeal. Once you plead guilty to this offense, it will go on your record. This is number 2. What happens the next time, Mr. Harrison? If I had one strand of hair, every time someone told me that it wasn't going to happen, I would have flowing, beautiful locks. You need to know what happens if you get pulled over again and you get charged with another DWI. What happens next time? You will be facing a 3rd-degree felony. You'll be facing a minimum of 2 years in prison, a maximum of 10 years in prison. If I were you, if you even have a sip of alcohol, I wouldn't get into a car because you were taking a humongous risk. You tell me now, it's not going to happen. You told me you weren't going to consume. Here we are. We've got you on a bond violation. Goes in here, goes out here. The only thing that matters are actions. Your words mean nothing. Actions speak louder than words, Mr. Harrison. How do you plead to the offense of driving while intoxicated, guilty or not guilty? I'm going to find you guilty. If you violate this probation, I'm going to issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out here in Orange. We're going to have a conversation as to whether you violated this probation. And if you did, you were looking at 180 days in jail. Do you understand? Okay. So the other thing that we have to do is the fines and fees for the DPS surcharge. It's a first. So it's a $3,000 fee, but let me ask you this. Is this a 0.15 or above?
To your honor.
And is it alleged? Is it alleged on the information?
I believe it's alleged to be a 0.15.
You should be walking out here with a $6,000 surcharge, but because they reduced it to a first, it's now a $3,000 surcharge. You must pay that in addition to the court cost. If you don't, for every $100 you owe, you will sit 1 day in jail. Do you understand? Okay. How do you plead to the offense? I will find you guilty. I'll send you to it. Good luck, son. Thank you, Ken. All right.
Judge, are you issuing a no voting license? He has the portable device at this time.
Okay.
His license is suspended until February 18th.
Okay. Yeah, we need to do a no driving affidavit. You are not allowed to drive. I don't care what you're doing in your life. You'll be signing an affidavit with me today that you're not driving. I hope you're not driving at all. Take it seriously, Mr. Hunter, because if I catch you driving, get ready. Okay. So if he decides if he wants to drive, he needs the interlock before he even gets into a car driving. So we have to amend conditions to be able to do that. So he can't just start driving. You cannot just start driving. You are required to have an interlock in your car. There is a paper that we sent to DPS so that every officer in the state knows that if you drive, you're supposed to have an interlock. You get pulled over and you're driving and you don't have that interlock, they're going to take you to jail. Do you understand? Okay, talk to Kim. She can help you out when that time comes.
Thank you so much.
Thanks, Kim. So the 3,000 plus the court cost, who's going to pay all? Carl, hey. Yes, sir. I did. Man, when I was 19, my hair was so beautiful. Oh, man, it was like.
History back then.
I know, it's good. Where the times have gone.
I have had a Christopher Gomez on your docket yesterday.
Yes,
I was not here because I took my wife to the doctor.
don't worry about it.
It was reset till January 22. However, you apparently signed a VDR. I guess it needs to be
Undone?
undone or rescheduled for one.
It's not on today?
We got a felony case pending.
You got a cause number for me?
Sure.
Okay. All right, what is it?
2544095. You got 2 cases. You better pull up one. He's got a felony case pending at 2/30 that was reset till January 17th. And I think the reason for the BDR is because of the felony. I'm not sure, but it doesn't really matter anyway. Just need you either set it for the 122 or undo it, whatever you want to do. Coordinate. It's already, I mean, the case is already reset to 122.
You see what he's talking about?
Yes, so the PBR was signed in one of the yesterday.
Right. So you want to put it, I guess I can just change the date, put it on that day.
Right, I had only put it out to the felony because I didn't know if it would come back this week or.
Do you want a different day or do you want that day? Okay, yeah. So we can just change the date on that and put the 122 on it and
Are
it's,
we keeping it like set for law enforcement to address the BBR or we're just missing this?
he's in custody. I mean, there's just, it's redundant. There's just no need. Sure. Yeah. Where is it?
It's on the case number to begin 489.
Okay, this other
Ready
case.
for activities. Because you signed it already.
254248.
Oh, it's still in ready for activities. Oh,
I would say hopefully it's set up. Yeah.
got it. Okay, done,
Thank you, Judge.
for sure.
So you're gonna continue supervision?
Yeah, I'll just continue because, I mean, really.
What's the last name again?
You ready for a cause number?
254248. Thank you, Judge.
Cases are active right now for the strip.
Hey, you may want to email
Is
her.
it 2B?
Because I remember specifically that she was.
Possible.
And that the brother says, I know you didn't say, or unless I misunderstood her.
2B, but he didn't.
I don't know. if that's-
It was a 2B and wasted because he had his other cases that he was, I think it was file. That's what.
Let me say, let me,
Yeah, I'll let you know.
yeah. Hey, Jillian,
Yes, sir. I have Ms. Layla White on docket. The state's offered a PTI. She said that, her phone was getting off spam, so she actually reached out to T-Mobile to put some sort of lock on her phone, and she wasn't getting any communications from the bonding company or from me during that time period.
come up, Miss White.
I will say before that time period, Ms. White was very communicative with me. I did speak with her regularly, and then all of a sudden I didn't, so.
You really expect us, you're gonna blame it on AT&T?
No, sir, I honestly,
You are even lucky to be getting a PTI offer at this point with as many times as you've taken off and the fact that your case is 250 days. We set cases for trial at 180 days, and your case is now 240 days old. What have you offered?
So we offered a 6-month PTI where she has to take a effective decision-making class and no drugs and alcohol.
Like the long effective decision-making class?
Discuss the online one.
Yeah, I mean,
If you're gonna do the,
Yeah, I believe it's a standard. Yeah.
that's what you guys are gonna do, then I'll give her a week to get it done, but I'm not doing any more. If you don't have it done in a week, I don't care if you come kicking, screaming, you blame it on whoever it may be, preventing you from doing it. I'm going to set your case for trial, or you're gonna end up taking another offer and you'll end up with a conviction, but you can't expect good things when you repeatedly take off, fail to communicate with your client, and you just go AWOL. Would we care if you don't care? It's a rhetorical question you don't have to answer. But that's what's going on in our mind here. Why would we care if you don't care? You have been given an opportunity now. The ball is in your court. You have 1 week. If you don't get it done in that week, that tells you that you truly don't care. And I won't take anything else. Do you understand?
yes, sir,
One.
next Tuesday.
Week. Okay?
thank you, Judge.
All right.
Right this way.
I got it all done. So last time he was technically here was maybe November 13th. He picked up a new case that was filed 12/11. You signed the 2B on
Okay,
12/16.
hold on. So he was here, last time he was here was,
November 13th. That
Okay.
was the last reset. He said he was, I think his appearance was waived, but he didn't say he wasn't here. We don't have a
He
signature
was
on file.
supposed to be here December 2 times.
December 12/19 and 12/26, you signed a bail order saying he was failed to appear both days, and you raised all of his cases on to 7503.
Yeah, he was supposed to be here 12/26.
Yeah, he didn't make that day, and he didn't make 12/19.
That says do not appear.
11/13.
11/13.
When we had him maybe here.
Yes, he's here on that day.
That was the last day he was here, and he picked up a new case 12/11.
Oh, he picked up a new case on 12/11.
That's when you granted or ordered, you signed it to me on 12/16, and then we raised all the bonds on 12/26 to 7503.
Judge Amprich. I was told Miss Galindo was negative, so I will wait for her, and then I guess.
She's here.
Oh, is she back?
Came
Oh,
up. All
there
right,
she
come
is.
up. So I'm gonna give her a portable device now, okay? And she's gotta stick with it.
Or just a portable breath or what? Okay.
Yeah, and we'll waive the fee.
Portable.
Today. Yeah.
Okay. We'll get her on a portable. and then-
Don't want any more issues. You're on notice, 3 strikes. It's out of my hands.
I'm sorry.
Okay, all right, guys, good luck. Thanks. Yeah. You are Mr. Prowler.
Yes, sir.
Is it, did I say it right? Prowler or Prol? Is it Prowler? Sir, you're charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 30th, 2024, the officer was dispatched to a doctor's office in Harris County, Texas, in regard to a criminal trespass. The officer made contact with the complainant and the witness, and the complainant and the witness stated the defendant had an appointment at the doctor's office several hours prior, was asked to leave, and the defendant stated he was not going to leave. The officer found the defendant and the complainant, and the complainant and witness pointed to him stating that that was the defendant. The officer told the defendant he needed to leave or he would be arrested, to which the defendant refused, stated, "Let's do this," and turned around, putting his hands behind his back.
Have a lawyer, sir?
Yes, sir.
Is he coming here today? Let's do this. I'm gonna hold off on it real quick. I'm gonna have you take a seat. Let's wait for your lawyer to get here and then we'll.
That's exactly what he told me. He told me to just explain to you that.
Don't. Let's wait for your lawyer.
He's asked me to, tell me to explain regarding the case itself. He simply told me to, tell you he'll be here as soon as possible.
Okay, just hang tight for me, take a seat for me, and then let me know when he gets here and then we'll continue. Okay, any THAs? We're done.
Time to go home.
Let's go home. I don't know, for now, I don't know, what do you think?
Well, if he's got felony on the 30th, can we do the 30th, and then that way, if he has to come to felony for it, he's got that.
I mean, we haven't even arraigned him. That's the problem. But I haven't even done an arraignment. I haven't done anything with him. That's why I brought you here, because he hasn't even, we've literally rolled his arraignment for 3 days in a row and he hasn't even made it here for an arraignment. So that's why I wanted to put you on to see how can I even get him here for an arraignment.
Okay.
So I
Can we
guess
do maybe
Monday? Okay. Yeah.
And then I'll see, I'll let you guys know that.
Yep. Counsel, you ready?
Yes.
Thank you for coming. Come on up, sir. And the name, what was the last name again? That's right.
Come on up.
So you are Kenneth Allen, correct? So Mr. Allen, we had started to do probable cause, but I wanted to wait. No, over there. so that we get your perspective on it. So, all right, so you stand charged with criminal trespass. You're facing up to 6 months in jail. We're going to do probable cause again now that your lawyer's here. Okay, please.
On December 30th, 2024, the officer was dispatched to a doctor's office in Harris County, Texas, in regard to a criminal trespass. The officer made contact with the complainant and the witness, who both stated the defendant had an appointment at the doctor's office several hours prior, was asked to leave, and the defendant stated he was not going to leave. The officer found the defendant, and the complainant and witness pointed to him, stating that it was indeed the defendant. The officer told the defendant he needed to leave or he would be arrested, to which the defendant refused, stated, "Let's do this," and turned around, putting his hands behind his back.
Is the witness.
So let me see, Your Honors.
I mean, he had authority to be there, and I know that you can revoke that, you know, when you overstay your welcome.
Yes,
right?
Judge. So the complainant is the office manager and the witness is security guard.
Okay. Did you want to add anything?
Well, Judge, my issue is he's been at that facility for years, and he has 3 separate doctors within the same UT facility. And he was there for his doctor's appointment. And there's some contention as far as whether he was asked to leave or not, considering that doctor's appointments take months to schedule in advance, sometimes up to 6 months. So I don't believe that if he had a right to be able to see the doctor, I don't believe that a person that's unidentified, the original complainant, I think her name was Amy, should be able to come in to tell him to leave, if in fact she even told him to leave. So I think there's...
I know, I guess here we have an office manager that's telling him to go, refuses to, so then the security gets involved.
Yes, Judge. And then he still refused to leave once security got involved. And we contacted the complainant as well, and to add...
You have spoken to the complainant?
Yes.
Oh, okay, tell me.
And the complainant said that the defendant was sitting in the lobby after his visit, and the reason he was asked to leave is because they had a prior incident where they investigated him doing some inappropriate conduct, and that's why they asked him to leave after his visit had concluded, and then he refused to leave.
Do they still want him not to go over there? I mean, I think that there's probable cause to go forward now. Did you speak to them? Tell me.
They said he's no longer a patient.
No longer a patient. Okay. So you can't go back there. Okay, Mr. Proler, you must find a doctor, but it appears that they don't want you to go there anymore at this particular doctor's office. Okay.
Well, Judge, not adding, like I mentioned, he has 3 separate doctors within the same building. So is the court asking him to stay away from that particular single
Correct.
office?
Right.
Okay,
So if you have business in another part of the building, you can go. Just don't go back to this office, because the chances are, if you go back there, they're probably going to call the police and they're going to charge you with another trespass. So don't go back over there, because they've warned you not to go back. If you go back, you can get charged again. Go to the other offices, like, hopefully they're just not next door, because that's going to be a real pain. But okay, so then just stay away from wherever that office is, and you can use the other 2 places. But I'm not barring you from the building, just from going back to that particular office. What is the confusion?
Oh, I want to bring to your attention this alleged other incident.
Doesn't matter.
Yeah.
Okay.
It doesn't matter. The only thing, my concern is going forward. Right. You were on notice now that you're not supposed to go. What suite is this?
It's a UT Physicians Bel Air station, so I don't know how they organized that office there. So I think just one system is not necessarily separate offices, like different. Just be
If he has 2 other doctors that he sees there.
And that's part of the issue, because again, so it's part of the same system. So I don't know. They do have multiple doctors there, but it would be at the same facility. And they told us that he's no longer a patient at the facility. So presumably that means no doctors there, but we could clarify if you would
I
like.
think you need to.
Yes.
You definitely need to, because this could be a potential problem.
Yes, we can
And
certainly
he's
clarify.
saying he's still seeing 2 other doctors
Yes,
there. They may not know of the other 2 doctors. You want to do that real quick to see, real quick? Can you give me 5, 10 minutes? Let me see. So, hey,